Chance and another on Societe General.
Mr. Chapman.
My Lords, I appear with my learned friend Miss Kim for the appellant in this matter, Societe General, referred to below and I'll refer to today as Soc Gen. My learned friend Mr. Onslow, King's Counsel, together with Mr. McWilliams, appear for the respondents, Clifford Chance LLP, CC LLP, as we shall call them, and Clifford Chance Europe LLP, CC Europe. And together we'll refer to them as either CC or Clifford Chance. My Lords should have before them both a core and supplemental bundle, a joint authorities bundle and a supplemental authorities bundle containing just one additional authority referred to by my learned friends.
Yes.
Sadly, my learned friend and I have noticed somewhat late in the day that in the printing, page 81 of the core bundle at tab 6, which is the form N460 recording the judge's reasons for refusing permission to appeal, was incomplete in that the box at the very bottom of the page had been printed blank rather than containing the 3 additional lines of reasoning. We're not sure we'll be making reference to that, but there are hard copies provided for my Lord so that the bundle is at least complete, and we obviously apologise for that printing error.
As mentioned, Mr. Chapman, we'll take a 5-minute break, morning and afternoon, but we will keep it to 5 minutes.
My Lord, of course, and I shall try, notwithstanding the inaccurate clock to my left, to pause at an appropriate moment.
Yes. Thank you.
My Lords, this appeal is concerned with the proper construction and meaning and effect of a series of framework agreements entered into between Soc Gen and CC Europe, and we say also CC LLP.
Is that right?
My Lord, yes.
You say it's construction.
Well, we say it's construction because once proper meaning and effect is given to the wording of the framework agreements, and in particular the later framework agreements, the 4th and 5th, in particular the 4th, the 2012 agreements going forward, then it necessarily follows, we would say, that the judge's conclusion as to authority must also be set aside, because if proper meaning and effect is given to the words of the agreement themselves, it is, as Lord Justice Mell said in granting permission to appeal, all the more surprising than in the case of the earlier agreements, if it were then to be said that CC Europe did not have either actual or apparent authority to do that which it said it was doing, namely to contract on behalf of CC LLP. I will come on to develop why we say that the specific findings in relation to authority beyond that overarching point fall to be set aside, and on the basis that they are findings which this court can properly interfere with and overturn.
You haven't appealed the decision, the findings on authority, have you?
Well, my Lords, we have. Our overarching ground of appeal is that the judge was wrong to conclude that Soc Gen had not established a good arguable case that CCLLP was bound by the exclusive jurisdiction clause, and that carries with it the point as to the meaning and effect of that agreement, and beyond that, if the agreement means what we say it says, and what it says on its express wording, how can it be said, applying the good arguable case test, that Soc Gen had not discharged the burden of showing it had the better of the argument that the exclusive jurisdiction clause applies?
But if A contracts with B and A says, I'm doing it on behalf of C, D and E, but is doing so without C, D and E's authority, there's no doubt about the interpretation of that agreement. It's clear what it says, but C, D and E just won't be bound unless you can establish, as a matter of agency or authority, that they're parties.
Well, look, with respect, we put it slightly round the other way.
They do, that's why I'm...
If here, Soc Gen and Clifford Chance Europe contract on the basis, as the judge found and as my learned friends candidly and rightly accept, he found, albeit implicitly, that CC Europe was intending to bind Clifford Chance LLP, then given that express and clear wording, and given the background circumstances including in particular the judge's finding that the true intention of the parties was that these framework agreements should govern the
Who are the
retained
parties?
Parties.
Who are the parties?
Well, look, the submission I was beginning to develop was that given the express wording of the facility agreement, CC Europe contracts for and on behalf of CC LLP, given that express wording, given also the other relevant circumstances, including in particular the judge's earlier finding as to the parties' true intentions for all of these framework agreements, the starting point is that the contract means what it says and that CCLLP is bound. Now, if CCLLP wishes to then put in issue that which appears on the face of the contract, namely CCLLP is not bound, and it is not bound because of an absence of authority, either actual or apparent, then it has to adduce credible evidence to support those contentions. And it has to be, in our submission, somewhat overwhelming evidence to displace the inference that otherwise naturally falls to be drawn from the express wording of the contract itself.
Where was the evidence from anybody at Soc Gen who was involved in the discussions leading up to any of the agreements as to what they understood or who they understood they were contracting with?
Well, look, there are obviously 2 points there. The first is that that's only relevant to apparent mandate, apparent authority, rather than the challenge to actual authority. To the extent that it's relevant to apparent authority, there was evidence that, as is obvious from the way in which SocGen puts its case, it always understood that these contracts governed the position worldwide and bound CCLLP. But there is another point, which I was going to come on to, which is that the authority point was somewhat of a latecomer to this party. And one has to bear that in mind, and it's something that the judge, with respect, did not. SocGen brought its application for a stay, and in doing so, it set out the relevant framework agreements and their terms. Clifford Chance filed evidence in response to that application, in which the point it took on the later framework agreements, the 4th and 5th, and the for and on behalf of wording, was not that there was no authority, it was that the wording for and on behalf of was a reference to CC Europe itself and only CC Europe. So there was no authority point when Clifford Chance put its evidence in response to the application. In its evidence in reply, SocGen then provided evidence as to the French law of agency. For the avoidance of doubt, so to speak, there's for and behalf of wording. Here's the French law and agency. And it was only after the French law and agency went in that Mr. Perrin's evidence was filed on behalf of Clifford Chance, for the first time putting in issue both actual and apparent authority. And one of the criticisms that we do make of the judge, and I'll come on to develop, is that he failed to pay due regard to that chronology, because his criticism in dismissing SocGen's evidence of being too high level and not clearly setting out which individuals it was based on, who it was saying that SocGen believed CCLLP to be bound, failed to pay regard to the fact that the point had developed in this way.
Where's that in your grounds of appeal?
Well, my Lord won't find how I've just put it in our grounds of appeal.
There's nothing in your grounds of appeal at all about authority.
Well, save, my Lord, that we say it's incorporated within the challenge to the overarching conclusion that CCLP should have been found, or rather, it should have been found that SocGen had the better of the argument that CCLLP was bound. And as is reflected in the fact that both the judge, in refusing us permission to appeal, made express reference to the authority point, and indeed, my Lord Justice Mayles made reference in his order granting us permission to appeal to the authority point. It was clear that both Lord Justice Mayles and the judge understood that that overarching ground engaged the authority point. Now, it is right, I accept, that the focus of our submissions has been on the challenge to the judge's construction, but that is because, as I've indicated already, our overarching position is, once you see what the contracts say, the idea that late in the day, Clifford Chance can adduce evidence, very short evidence, and a very short witness statement, from someone saying, I simply don't believe that there was authority. No suggestion they've checked the files or looked for any documents, simply based on belief and recollection. Simply falls away.
Can we just go back I don't want to take you completely out of your course, but it's quite helpful to understand what the issues are. Going back to 2008, which is when CC LLP is actually retained.
My lord, yes.
At that point, there have been two framework agreements. But there's no doubt that certainly when they were entered into, CC LLP was not party to those. And we know that because CC LLP hadn't been formed, as I understand it.
No, not until the end of 2006.
So we have two framework agreements to which CCLP was not party, and there's no question of agency arises, simply not party. So when CC LLP is retained in 2008, you cannot say that they became party to those framework agreements as a matter of agency, can you?
Well, my lord, as the judge partially reflected in paragraph 85 of his judgment, our position below was what precisely happened on the transfer of business between CCUS LLP and CC LLP on its incorporation in 2006 is uniquely within the gift of Clifford Chance.
Yeah.
And the only evidence that Clifford Chance produced on that was there was some type of transfer. We're not going into any details. CC LLP, the current LLP, simply did not exist until that restructuring took place. And our position before the judge, and we don't resolve from this, is that what actually matters on our primary case, and remains our primary case, is what the later framework agreements mean, because each framework agreement takes precedence over the earlier. And there's no doubt in our submission that CCLLP was a party to the later framework agreements.
Well, we'll come on to those. Let's look at 2003 and 6 at the moment, because
Yes.
your first ground of appeal says the judge wrongly held that the Clifford Chance entities were nonetheless not bound by the terms of the 2003 and 2006 agreements. What I'm trying to ask is, how do you say Clifford Chance CCLP LLP became bound to the 2003 and 2006 agreements?
Well, my lord, on that, as we set out, I think, in paragraph 34 of our skeleton, what we say is that in those earlier framework agreements, there was ambiguity as to what the phrase "the firm" meant. Because on the one hand, you had the contracting party identified originally as CC Celifer. Let's keep it as CC Europe for simplicity. But the terms of the agreement and how the firm is then used refer to offices throughout the world. Now, given that ambiguity, and given what were the undisputed principles of French law of contractual interpretation, we say the court erred in failing to give effect to what the judge found to be the parties' true intentions, namely that the agreements were intended to cover the relationship between Soc Gen and Clifford Chance entities worldwide. So we would say when they were
in that sentence, who were the parties? I mean, I find you're throughout this, and you refer to paragraph 34 of your skeleton. I mean, it's a similar issue. When you say the party's intention, who, which parties are you talking about?
well, our case on the 2003-2006 agreements is similar to that on the later agreements, namely that the contracting parties were all of the CC entities, not just CC Europe in Paris.
Well, at the time those agreements were entered into.
At the time they were entered into. Now, we then had to grapple.
So,
Sorry.
what? Couldn't be LLP.
No, that was the point I was going to say. We then had to grapple with the fact that LLP did not exist at that time. And as to that, bearing in mind that the litmus test throughout all of this is who has the better of the argument that CCLLP is bound or not, and bearing in mind that the framework agreement that was, so to speak, in play when the dispute arose is the later framework agreement. So that, so to speak, this is so much background rather than identifying the agreement that we say governs the position, not least because we have to accept, as is the case, that neither the 2003 nor the 2006 agreement had a jurisdiction clause within it. They had French governing law clauses, but they did not have jurisdiction clauses. So our focus has always been on the later agreements that do include the jurisdiction clauses. We have to, of course, and do provide an explanation as to the meaning and effect of the earlier agreements, not least because in attacking the judge's reasoning, the judge dealt with matters chronologically, and his analysis of the earlier agreements informed, we would say with respect, infected his analysis of the later agreements. One way of looking at this, notwithstanding what we say about the 2003-2006 agreements, but perhaps picking up on the point made by Lord Justice Mayles in giving permission to appeal, is that there may well have been a failure in legal drafting in the 2003 and 2006 agreements if they did not have the effect, which we think the judge, they should have done, reflecting the parties' intentions as he found them to be, and certainly we say what the parties' intentions were. But that any infelicities or defects in the drafting of the earlier agreements was effectively corrected by the later agreements. Because once you get to 2012, you then have a very clear express wording which sets out and puts beyond doubt the mechanism by which the entity beyond Clifford Chance Europe in Paris is a party to those later framework agreements.
Forgive me, surely the first question has to be addressed is what were the terms of the retainer of CC LLP in 2008? Must be the starting point.
Well, with respect, not necessarily, given that the 2012 framework agreement provides for it to take precedence over any other arrangements between Soc Gen and its various entities and CC.
No, you can't. I mean, I think my lord's question to you is you can't retrospectively change history.
What
was the retainer in 2008?
Well, look, I'll come to what the retainer was, but just as to the changing of history, or I think as the judge put it, changing the position midstream, we say with respect there's no difficulty about that. But quite often, contracting parties, including professional service providers, will change and modify their terms and conditions throughout the period of a retainer. So for example, as might have happened here, we don't know because Clifford Chance haven't told us, when there was a change from CC US LLP to CC UK LLP, there would have been really quite a fundamental change because there would have been a change in the contracting party who was providing the legal services. But one sees, for example, in other contexts where at a lower level, as happened here, the fees to be charged, the hourly rates are changed. But at the other end of the spectrum, you have a change in contracting party, either because there's a restructuring from, as there was here, a US LLP to a UK LLP. Often one knows of restructurings based upon the change from a general partnership to a limited liability partnership. Equally, there may be cases where a professional service provider decides to change their terms and conditions in the course of a retainer to introduce an express jurisdiction clause or a limitation of liability clause. So
the difficulty you have, though, is that you do not have any written framework agreement or retainer to which CC LLP is expressly a party. So you have to mount a case that they are parties to that retainer by some mechanism. And therefore one has to look surely at the history of the dealings between your clients and CC LLP to see how that's evolved. And it seems to me that one cannot get away from the starting point is when CC LLP was retained in 2008, what was the terms of that retainer? Because if you're going to say that later they were bound by the terms of another agreement to which they are not expressly parties, you've got to demonstrate why it is that the agreement with CC LLP changed by that agreement to which they're not parties or not expressly parties. And as I understand it, the way you do that is you say, well, although they weren't named as a party, they gave their authority, express or maybe ostensible authority. But whether you can find that authority and whether you can find it's apparent must be influenced by the fact that there is already a written retainer expressly with them in 2008 or impliedly with them.
Well, my lord, certainly the existence of the ongoing retainer is, of course, one of the circumstances that has to be taken into account. With respect, it's obviously correct that CCLLP is not named as a contracting party in the sense of being a contracting party who is contracting on its own behalf in the later framework agreements. But we, of course, do say that the express wording of those framework agreements make it clear that CC Europe is rendering them a party by contracting for and on behalf of CCLLP. That's what the contracts say. Now, if that's what the contracts say, and bearing in mind that these aren't, so to speak, unsophisticated entities with no knowledge of the law, if CC Europe in Paris is expressly saying, as it did, we are contracting for on behalf of CCLLP, then the obvious position, absent, we would suggest, compelling evidence to the contrary, is that that contract means what it says, and CC Europe has bound CCLLP because it had the authority to do so.
But the difficulty I have with that, Mr. Chapman, is that the judge considered the evidence, and whether it came in early or late or whatever, it was before him, considered it, and he found that he accepted Mr. Perrin's version of events, and there's no challenge to that. It's not in your grounds of appeal.
Well, we would say that we are challenging that because...
Show me where. Which paragraph, which sub-paragraphs of your grounds do you say challenges the judge's findings, detailed findings as to his assessment of the evidence from Mr. Perrin?
Well, my lord, we don't specifically in the grounds of appeal to descend to that level of detail, but one sees, for example, in paragraph 1, subparagraph 2 on page 15 of the bundle, in a position that finds an echo in the order granting us permission to appeal, that we do specifically pray and aid the express wording of the 2012 and 2015 framework agreements. And our position is that once you pay due regard to those words and apply the test of good arguable case, it cannot be said, as the judge seemed to conclude, that Clifford Chance had the better of the argument on whether CCLLP were bound or not.
Well, I can see that you might say there is an agreement to which made by A, in which he says he's making it on behalf of B, and given the relationship between A and B and all the surrounding facts, you might think that A wouldn't do that unless he had B's authority. And you might say that that puts some sort of evidential burden on B to say that A did not have his authority to do that. But here, there was evidence, and the judge did consider it, and he did come to the conclusion that, in fact, B had not authorised A to enter the agreement on his behalf. So, although you may be right that there is perhaps some sort of evidential presumption that Clifford Chance Europe wouldn't have said that without the authority of the constituent members of the group of firms, we move past that because the judge did actually consider the evidence from Mr. Perrin and did make a finding that, notwithstanding what was said in the agreement, there wasn't in fact actual or apparent authority. And there's no appeal against that.
Well, we say with respect that there is, because our appeal at its heart says that the judge failed to pay due regard to the express words of the agreement, and also inherent within that to the background relationship between the parties based on the 2003 and 2006 agreements, which is why we bring a challenge to his findings as a matter of construction in relation to those earlier agreements. And having made that challenge, the question of authority in our submission was always in play, so as to speak, and that's recognised, as I've indicated, both in the judge himself in refusing us permission to appeal, but also in the order granting us permission to appeal at tab 8 of the bundle, page 95. Where at paragraph 2, Lord Justice Mayles recorded the judge accepting at paragraph 87 that the 2003 and 2006 framework agreements set out principles that were evidently intended to be applied to work done for the applicant by CC entities across the world. It would, at least at first sight, be surprising and would represent a failure of legal drafting if the agreements failed to give effect to that intention, but that appears to be the result of the judge's conclusion. And then this, it would be even more surprising if CC Europe purported to make such an agreement on behalf of CC entities worldwide, as it did expressly from 2012 onwards, but had neither actual nor apparent authority to do so.
Well, those are undoubtedly good points, but I'm not sure that the expressions of a Lord Justice on granting permission to appeal, as it were, answer the points. He's raising issues, and I think that you're going to have to persuade us on the grounds of appeal that you've got. I think I understand why you refer to what Lord Justice Mayles said, but he's not a member of the Constitution, and he's only expressing very provisional views.
No, but I think, my lord, the principal purpose of showing my lords that passage was to indicate in our submission that it appears to have been understood by Lord Justice Mayles in giving us permission to appeal in identifying why the appeal stands a real prospect of success, that this point was a point to which the grounds of appeal gave rise. Because the Lord Justice here is, the learned Lord Justice here is setting out his reasons as to why the appeal stands a real prospect of success, namely that there is a real prospect of success, that CCLLP is bound by the agreement on jurisdiction. And so we would say, although we have not spelled out in writing in more granular terms the challenges to the findings on authority, because the overarching challenge is, once you give effect to the wording, that should really be the end of the matter. It was, we would respectfully suggest, clear that the appeal stands a real prospect of success because we stand a real prospect of successfully challenging what the judge had found as to actual and apparent authority, because that's what Lord Justice Mayles was saying in paragraph 2.
Well, in Lord Justice Mayles's reasons, we shouldn't get too, for reasons of what you said, being hung up about them. But he talks about, at the end of paragraph 1, likely represents the way in which Clifford Chance, which he puts in inverted commas, held itself out to the world and would have been viewed by clients. What evidence do we actually have of what, quotes Clifford Chance, held itself out to your clients?
Well, we have the evidence.
Specifically LLP. I mean, as a matter of English law, I'll just start with English law before we get into French law. If you can't have a sort of self-authorising agent, and generally, as I understand it, apparent authority relies upon a representation made by the principal, not by the agent as to his own authority, or the putative agent as to his own authority. I mean, the fact that somebody says, I act as agent for somebody else, doesn't in fact amount to apparent authority, does it?
My lord, as a matter of English law, no. Right. As a matter of, I mean, there are two issues here, of course. The first is actual authority. I mean, unless Clifford Chance, or rather put it the other way, unless the judge was right to find that Clifford Chance has effectively discharged the evidential burden, which my Lord Justice Phillips was identifying, fell upon it, given the express wording and the background circumstances here. then the natural inference to be drawn from the wording of the contract itself and the background circumstances that there was actual authority. And to put it again more accurately and rooting it in the test here, Soc Gen had the better of the argument that the exclusive jurisdiction clause applied.
Could you be specific about the facts that you say give rise to the inference that there was actual authority
Well, there are two principles.
in the teeth of Mr. Perrin's evidence?
Yeah, the first is the express wording of the contract itself in circumstances where the contracting party purporting to bind its principal is a law firm. So you have the express wording coupled with who is actually providing the wording. Secondly, the broader circumstances are the existence over many years of a series of framework agreements which the judge himself had found the parties had intended.
The parties, which parties?
The parties being, on the judge's findings, Soc Gen and Clifford Chance Europe in its predecessor practice. On our case, Clifford Chance Europe and the other Clifford Chance entities, setting out the terms that should apply to retainers between Clifford Chance
You've just
entities.
identified though the judge's finding. I mean, this use of the word parties is so difficult, makes this case so difficult. You know, the judge's findings related to the parties on the face of the agreement, namely CC Europe and Soc Gen, didn't they?
The judge's findings, yes.
But you don't. Where's the challenge? I'm struggling with the challenge on facts to that.
Well, we say, I mean, it goes back to the point I was making really from paragraph 34 of our skeleton, that there is ambiguity in the wording of the earlier contracts themselves as to the meaning of firm, and if you then apply the French law principles, that also have led to the conclusion that the entities beyond Paris were bound. But there are also...
So how does that work? Because that you're saying that an ambiguity can lead to the conclusion that a party who is otherwise not bound by the contract is bound by it. That can't be right, can it?
Well, it is respectful, my lord, not that a party who's not otherwise bound. It's only identifying first of all, what does the contract mean and who are the parties to it. There's
Those are two different questions, aren't they?
Well, they're two related questions because who is the party? Well, there are contradictory indications. You've got in the earlier contracts a reference in the preambles to CC Europe and its predecessor firm, but then immediately one gets into the operative provisions, indications that actually the contracting parties are not just Paris, because there are references to the firm's defined terms, offices worldwide. And we know, and it wasn't in dispute, that Paris only has an office in Paris. Then you have all of the other contrary indications, contrary, that is, to the indication that the only party to be bound was CC Europe, which appear in all of the framework agreements, and in particular in the later framework agreements, as to the mechanics as to how individual retainers are to be managed in different jurisdictions, the fees to be charged in different jurisdictions where there are agreed rates, including for the United Kingdom, reporting obligations, rebates, all of which, insofar as the Golders litigation is concerned, the judge found correctly Clifford Chance LLP abided by. So they charged the agreed rates to be found in the framework agreement, and they charged the agreed rates as they changed from framework agreement to framework agreement. They provided a rebate on their fees by reference to the agreed rate in the framework agreements.
So what is the legal mechanism by which you say that factual circumstance of charging the agreed fees and or the fees that were set out in these subsequent agreements and the rebating mechanisms, what's the legal method by which that made LLP, sorry, that party to the later agreements? Can you identify what legal principle you say operated to make them a party to those agreements?
To the later agreements, we say court need not even get to the stage of looking at compliance with the terms, because on the later agreements you have the express wording for and on behalf of, where you've heard my submissions as to its effect and the inference that falls to be drawn. If you then add in to the other circumstances, which I've already identified as the pre-existing relationship, the series
But
of
are you
framework.
saying that the mechanism is that is evidence of actual authority, or are you saying it's evidence of ratification or something as we would call it under English law?
I can't say ratification because there was no evidence as to French law of ratification. But
Why I was asking actually.
we say that if, as it should be, the starting point is this is a contract that on its face purports to bind CCLLP, then you really need some quite overwhelming and extraordinary evidence to displace the conclusion that naturally follows from that, namely that CCLLP are bound. Now, CCLLP put in issue that they are not bound. They put in issue that they're not bound as a matter of construction, and then latterly they put in issue that they are not bound on the basis that there was no actual or apparent authority. And one then has to look at the evidence such as it was, filed on behalf of Clifford Chance, and on the other side of the scales, look at, first and foremost, the wording of the contracts themselves, not just the for and on behalf of, but all the other terms to which I've made reference. And at that stage, you weigh in that side of the scales the fact that CCLLP, who disavows being bound by this contract, actually abided by its terms. You also put into the scales the fact that there was no competing written terms of retainer. And one then has to stand back and ask on the probabilities, applying the good arguable case test, who in those circumstances has the better of the argument? And one comes back then to, which I won't perhaps make reference to again, the comment made by Lord Justice Miles in giving permission to appeal. In all of those circumstances, it would be surprising to say the least if the earlier framework agreements didn't bind, but all the more surprising if the later framework agreements did not do so. And that's really what lies at the heart of this appeal, is that one, of course, has to look at the earlier agreements because they provide the background to the position. One has to look at 2008 when the Golders litigation commenced, or rather the retainer in relation to the Golders litigation commenced. But the position ultimately is governed by the 2015 framework agreement, because that's the framework agreement that we say was in place at the time the dispute arose, and it superseded all of the prior agreements. And there are various different ways that one can seek to displace what we say is that inevitable conclusion. And the way the judge did it, as we'll come on to see, is by starting with 2003 and 2006, and then in our respectful submission not paying sufficient regard to the inherent probabilities once you got to 2012 and what the agreements actually say. But my lords, if we have not, and we haven't, spelled out in more granular detail that our appeal includes, as we say it does, and as we say as reflected in the documents I've taken you to, a challenge to the finding authority, then obviously we apologise for that. But the point we'd say is plainly there and always has been there. My learned friends make quite a lot of that authority point in their skeleton argument, so that there's no suggestion that they're not aware of the point, or they'll be prejudiced by us advancing the appeal as we do on the basis that the judge's conclusion as a whole is impugned and should be set aside for the reasons that we identify.
If it were the case that in 2008 you retained CCLLP on an implied retainer, which was properly considered to be governed by English law and jurisdiction, in relation to a particular piece of English litigation, wouldn't it be surprising and rather difficult to understand why at a later date by some process that was changed so that the law and jurisdiction governing that retainer in relation to English proceedings became governed by French law and jurisdiction?
My lord, no, particularly given the background here, and I won't repeat the submissions I've already made as to the background as to the existing framework agreements and their terms, but there is an important background in terms of the Golders dispute itself, because consistent, we say, with what the parties' intentions are to govern the relationship worldwide, although there was litigation in England, of course there was also litigation, albeit undertaken by another firm in Turkey.
Yes.
But also, if one looks at the origin and development of the retainer, it was Clifford Chance's evidence and accepted that Soc Gen first approached the Paris office in relation to the Golders dispute. Paris referred the matter to Dubai, who started acting in relation to it. Dubai then transferred the case to London, and in the course of the retainer, Clifford Chance lawyers from London, Dubai, Paris, Frankfurt, and I think elsewhere, were all involved in the case. So that those various different offices were involved in assisting.
But certainly the judge found that the Dubai retainer, such as it was terminated.
That appears to be what he found, yes. And
There's
then
no challenge to that.
there's not. And then there was he found
so
there's
then you
been
have a new retainer of CCLLP. But must be.
my lord, yes, that's what the judge has found.
Yeah.
And we say, even assuming that the terms of that implied retainer, not recorded in writing, did not include, on this assumption, as we say it did, not least because of CCLLP's conduct, the terms of the then existing framework agreement. There's nothing surprising in the circumstances of this case that come 2012 and the framework agreement expressly replacing everything that's come before, that the position would be as we say, namely that whatever the position hitherto, going forward, it's French law and it's French jurisdiction. And that...
What do you mean by going forward? Do you mean that a dispute that arises in relation to conduct in 2008 would still be governed by English law?
My lord, yes, because the contract is then replaced by the new contract, and that governs the way in which the dispute's going to be governed as well.
Well, no, I think my question was that in 2008 it's governed by English law, because that was the original agreement. Are you saying that a later agreement in 2012, let's say, that their disputes be governed by French law would be backdated, would have retrospective effect?
Well, to that extent it would have retrospective effect, because the parties are saying the 2012 agreement supersedes everything that came before. So now the contract between us is governed by French law and has an exclusive jurisdiction clause providing for the High Court in Paris. If a dispute now arises between us in relation to conduct, whensoever that conduct arose, it now has to be referred to the court in Paris. My lords, can I just perhaps show you, my lord, some documents? I'm conscious that your lordships would have had an opportunity to look at some and possibly all of these already, but just so that perhaps I can elaborate on some of the points that I've endeavoured to make in answer to the questions that have been asked of me. My lords will know that in these proceedings, Clifford Chance seek negative declarations, and in particular declarations that they are not liable to my clients in respect of legal services provided in relation to the Golders dispute. And they also seek declarations that CC Europe was not retained by Soc Gen in relation to that matter. Now, if one perhaps just turns up briefly the claim form at tab 7 of the core bundle, page 82, and it's on 82 is the first page of the claim form. The details of claim are set out at page 83. And really, I just make reference to this, first of all, so that my Lord can see the nature of the relief being sought, but also the period we're talking about. So in paragraph 2, it said that CCLLP acted for the defendants in the Goldust litigation between 2008 and 2017. And one can see the substantive relief sought by the second claimant, CC Europe, at 6.2 in particular, albeit one sees from paragraph 6 that both claimants are apparently seeking all three declarations. Now, my Lords may have picked up from the papers that there was a standstill agreement between the parties between March 2017 and January 2023, which perhaps explains the time it then took for these proceedings to come on and the application to be heard by the judge. Now, as I've already indicated, it's accepted that the present dispute between the parties arose during the currency of the 2015 framework agreement. And that framework agreement, as I think I've already indicated as well, was the 5th of 5 of the framework agreements which were concluded. That agreement simply extends the term of framework agreement 4 by a further year to the end of December 2017, along with making some changes to the agreed rates to be charged. So it's really the 4th framework agreement which we say is of particular relevance here. That is to be found in the supplemental bundle in the original French at tab 7, but in the English, to which I will make reference, at tab 8. So there we see the general terms and conditions, and the Lords perhaps might know that the agreement is in 2 parts: general conditions and special conditions. And over the page at page 148, we see from the preamble what's said about the terms and conditions, and in particular, in the penultimate paragraph under the preamble, the terms and conditions apply to all relationships of the Societe Generale group and its subsidiaries and branches in France and outside France. And the terms and conditions shall prevail over any other agreements, contracts, or terms and conditions of the firm, and supplemented by special conditions. So there's the taking precedence point to which I made reference a few moments ago. There are then various provisions in clauses 2, 3, and 4, which...
When it says prevail, I'm picking up a point now made by Lord Justice Zacaroli. When it says shall prevail over any other agreement, that's normally means shall prevail over any other current agreements, not shall completely replace any prior agreement.
Well,
it's dealing with current conflicts between agreements.
Well, my Lord, except that, of course, at this point, the retainer is still an ongoing retainer, and we would say, therefore, falls to be subject to these updated terms and conditions. Now, over clauses 2, 3, and 4, there are various provisions dealing with what might be called the mechanics for file handling, which mirror the types of terms that appeared in the earlier framework agreements. And then at clause 5 of page 150, my Lord will see reference to preferential price conditions, to which I'll return. And at clause 8 on page 152, an obligation for the firm to submit a report in the terms of Appendix 3, to which will come as well. And then for present purposes, of course, of key relevance at clause 12 is the governing law and jurisdiction clause, page 153. And I'll come back to make some submissions about its meaning and effect. Those are the general conditions. The special conditions begin at page 154. And it's here that at the top of page 155, one sees the wording to which much reference has already been made by me this morning, namely that Clifford Chance LLP Europe, acting in its own name and on behalf of all offices of Clifford Chance LLP, is entering into the contract on that basis. Then we have some wording in the preamble and the term at clause 2. Clause 3.2 we say is of interest. One sees that in each country where the SG Group and Clifford Chance operate, the relationship is managed cumulatively by, and one then sees reference to the individuals on either side. That's important because CC Europe only operated in Paris, so again is an indication again that this contract is to have effect beyond CC Europe. Clause 4 deals with preferential price conditions again, and one sees that within the body of clause 4 that France, the UK and the US are specifically identified as jurisdictions where specific rates will apply. Now, my lords, I mentioned the reporting pro forma. That's Appendix 3, which is at page 163 of the bundle. And this again mirrors, in large part, a obligation that appeared in the earlier framework agreements. And you'll see that what's required is effectively an Excel spreadsheet setting out details of the matters being handled by Clifford Chance. And those matters should include, a little way down that page, the firm's office, and also details of the SG branch or subsidiary in the country where that is located. At page 173, there is a Clifford Chance firm contact list, so Clifford Chance firm singular, and there is then a contact list setting out the particular Clifford Chance partners in various jurisdictions throughout the world, listed by country. And at Appendix 7, beginning at page 175, one sees the maximum hourly rates for France, the United Kingdom and the US set out.
Was there any evidence as to how those rates came into this agreement?
There was no evidence, I think, as to how those rates came into this agreement. What there was evidence that these were the rates that were in fact charged by CCLLP on the gold dust dispute.
Your client must presumably have had somebody who was aware of how these rates suddenly materialised in this agreement. I mean, that's what this is really about. It's a negotiation of discounted rates asked for by Societe General and Clifford Chance in the various jurisdictions were willing to charge.
Well, and possibly the other way, that the fees that Clifford Chance
takes two to tango.
Yes,
but I'm just asking, where was the evidence from anybody at Soc Gen to say, for example, look, there was a big negotiation and we understood that Mr. The gentleman who signed it on behalf of Mr. Worley had consulted with all the different offices worldwide, and that was the basis of the rates, because he presumably wouldn't have, without at least consulting with the entities worldwide, the authority just simply to pick a number out of the air and say, well, that's what a US partner can charge. Well, where's the evidence of it?
Well, look, there was no direct evidence from a witness saying I was the person negotiating this, and this is what I understood. Well, could be a whole raft of reasons, but that in itself is not in evidence. So, other than one might view this through the other end of the telescope and say,
you're asking us to say the judge was wrong not to draw various conclusions as to the authority of Mr. Worley to actually to do what he purported to do in this agreement. So it's a bit harsh on the judge when the judge was not actually provided with the sort of evidence that must have been available to SocGen to show why they thought that Mr. Worley had the authority of the various different Clifford Chance entities.
well, I think one can view it with respect to the other end of the telescope, which is that it's highly unlikely, to the point of being improbable, that Mr. Worley and his colleagues at CC Europe were on a frolic of their own and dreamt up these rates.
So you say.
And what we do have evidence of, and as the judge found, is that CCLLP were clearly aware of the rates on the Gold Dust dispute because these are the rates that they charged.
Right. But if you're trying to make good the claim of actual or apparent, or certainly apparent authority, why was there no evidence from Soc Gen personnel explaining how these numbers came into this agreement?
We'll also have my overarching point as to the fact that the document speaks for itself, and that type of evidence was not likely to.
So you're saying the judge was wrong when the judge said, "I don't have any evidence."
Well, he was wrong. This is why we've put this, although, so to speak, I've taken my medicine on this, as the judge not paying due regard to what the contract says. Here are agreed rates for London in a contract that says it's made on behalf of CCLLP practising in London. These rates are then on the evidence, and as the judge found, the rates that were in fact charged. And it wasn't just happen chance. As the rates changed in the framework agreements, those were the rates that were charged. The rebate provision, which we may come to, of 7% on the fees in the framework agreement was applied by CCLLP. Is it really going to weigh terribly much in the balance to have someone come along from Soc Gen and say...
But are you saying the judge was wrong in his assessment of the weight of the evidence?
He was wrong in his...
Your whole appeal is couched in terms of interpretation and construction. What I think you're now sort of be putting to us is to say that the judge didn't give appropriate weight to various factual matters.
Well,
in failing to conclude that there was actual or apparent authority.
Well, we're still rooting ourselves firmly in the wording of the agreement. That's why we say that.
Yeah, but not as a matter of interpretation. You're doing it. I think it's becoming more apparent as a matter of the judge didn't have appropriate regard to various pieces of evidence of which the words were wrong. It's not a question of interpretation.
Well,
I mean, it's perfectly clear what the charging rates were. It's not a question of interpretation or construction. I think you are criticising the judge for failing to have regard to various different pieces of evidence, but that's not the way your appeal was mounted on paper, and it's not, in a sense, you didn't give the judge the factual material to assist that.
Well, my Lord, I'm certainly not going or seeking to go beyond the factual material that's before the judge, and the primary point that we make here is one based on the wording of the agreement. Is that what does this agreement mean by reference to these agreed hourly rates applying in the UK, if not as a further indicia on the face of the documents? Leave aside the evidence that these were the rates in fact charged, as indicia on the face of the document and its terms, which provide for preferential rates to be charged, and then set out in this type of granular detail what those rates are.
But can we take it for read, at least for the moment, that the framework agreement on its face is made by Europe on behalf of CCLLP, and that it records information which must have been obtained from CCLLP, and on its face, it entirely is consistent with your case. Let's take that as read. So all interpretation issues are in your favour. Interpretation of this agreement. But then along come CCLP and say, well, notwithstanding all of that, we didn't actually authorise any of it. Now, it seems to me the judge has got to grapple with that issue. He can't ignore it. He can't say, I'm sorry, CCLLP, Europe did this, you're bound by it. He has to examine the question of authority. And that's then when he looked at what the evidence was, and weigh it against, you say he has to weigh that with the improbability, you say, that CC Europe would have done all this without authority. Is that right?
My Lord, yes. And
so it is a matter of weighing the document and all its what it says on its face, with then the counter argument which is put forward. You say belatedly from Mr. Perrin that notwithstanding that this looks like a document that binds LLP with its authority, in fact it doesn't. And so aren't we then looking at what the counter evidence is and the judge's approach to that? Isn't that the key question?
Well, my lord, yes, and the only caveat why I pause is that there are points that can be made on the adequacy of the evidence, and for example, the judge himself says that Mr. Perrin's evidence was short. He gives a reason for that, which I've given an explanation as to why that might not be right. But the overarching point on our side of the scales against the sort of assertion of the absence of authority are the terms of the agreement itself, and one obviously starts with it says it's to bind CCLLP, and that's what
Take all that. We accept that. Let's assume that we assume everything in this document,
yes,
on its face, points to it being entered on behalf of CCLLP. But at the end of the day, the difficulty is you can see that it was signed by the managing partner of Clifford Chance Europe LLP. Isn't signed by Clifford Chance LLP. So
no.
So then the point is taken against you. This wasn't done with our authority, and you can rightly look surprised and say, "Are you really suggesting that a Clifford Chance law firm purported to act on behalf of other entities in the group but didn't have authority to do so? You can't be serious," as you say. But then there's evidence, and the judge has to address that. So don't we have to? Isn't that the big question here? Is does the evidence? Was the judge justified in saying that, given that evidence, Clifford Chance LLP had the better of the argument?
Well, my lord, yes, but as part of, we would say, applying the French law of giving effect to the agreement, if then the challenge is made, the judge has to say, well, what does this agreement mean? And that includes who are the parties.
It's a binary question. Either there was authority or there wasn't. It's not a matter of the giving effect to the agreement. I mean, the agreement either binds Clifford Chance LLP or it doesn't. So no matter how strongly it's worded, if it didn't have authority, there wasn't authority. And that's, for us, that's commonplace analysis, isn't it? It's not difficult to say. However strongly X says he's got the authority of Y, if he doesn't, he doesn't.
But my lord, that is right, and subject to perhaps one wrinkle to which I'll come as a matter of French law, seems to be positioned as a matter of French law as well. And so it is to that extent a binary question. And we do say on this appeal that the judge erred in not paying sufficient regard to all of the things that my lord's hypothesis to me is premised upon, namely the wording of the agreement, when it came to then finding that simply on the basis of Mr. Perrin's say-so, all of the natural inferences that would be drawn from the wording of the agreement itself, and one might add the relationship between the parties and the history, were somehow upended. And instead of SocGen plainly having, at the very least, a good arguable case that this agreement does what it says.
Well, the better of the argument.
Well, the better of the argument, yes. I mean, the better of the argument,
Yes.
that this agreement does what it says, simply on the basis of one short witness statement, that somehow reverses everything.
So are you saying, I mean, because conventionally when this sort of appeal is launched, it's the judge's finding that there was no authority given by Clifford Chance LLP to Clifford Chance Europe for the framework agreement to be entered into was contrary to the weight of the evidence and failed to have regard to the following facts, X, Y, Z. I mean, that's not the way your notice of appeal reads at all. I mean, putting aside that 3 and 4 talk in terms about interpretation, I struggle to get any of that from round 1, subparagraphs 1 and 2. I mean, is this an appeal on fact against the judge's factual finding that there was no authority, or what?
Well,
That's why I picked you up the very first time, in a sense, you opened this appeal, when you said it was a question of construction.
one would understand that. I mean, one can understand, not least because of the interventions from the court, as to why it can be characterised, we would say, in both ways. But and we accept that our challenge is to the judge's finding that SocGen did not have the better of the argument that CCLLP is bound. And we say that the fundamental error that the judge made there was not paying due regard to what the contract meant, including as to what it said about who the parties to it were and who it said was being bound. Now,
I don't have any doubt, I don't have any difficulty in interpreting, for what it's worth, what the agreement says in terms of who it's intended to bind. That seems to be pretty clear. It says, entered into by Europe on behalf of and with the authority of. I mean, there's nothing really unclear about that. That's pretty clear as a matter of interpretation and construction. I mean, there's a lot less clarity about 12 in terms of the governing law and the timing of what disputes it relates to, but that's another issue. But the real issue is not what it means or whether there's any ambiguity in meaning or anything that needs to be interpreted. It's the question of who is the agreement between, which is a factual question.
my Lord, as I indicated earlier, with respect to course, we agree that there's no difficulty in giving meaning and effect to the words that were in fact used, and implicitly at least, the judge had no difficulty, although he makes no express finding, that the wording means what we say it means. And I think my own friends very helpfully have indicated that they agree that that implicit finding is made. The reason why I pause, and this may be in part a historical explanation as to why the matter has been presented as it has, is that Clifford Chance's first answer to why the facility agreement in 2012 and its exclusive jurisdiction clause did not bind CCLLP was a construction point. Mr. Hewitson said that the for and on behalf of wording didn't refer to CCLLP, it just referred to CC Europe. And then Mr. Perrin then comes and gives his short witness statement saying, well, I don't believe that CC Europe had authority. And that then finds its way into the judgment as it does. Now,
the only evidence is Mr. Perrin's. I mean, Mr. Hewitson is just, sorry, Mr. Hewitson is a solicitor giving a view as to what he thinks the agreement means.
well, presumably on instructions. But
Okay, assuming he does, where does that take anybody?
well, only to this point, namely that there was a construction dispute as to what the wording meant. And then we now go further, given what the judge has found, and saying, well, if you give effect to what the words mean, as to who the parties are, who's being bound, who is said to have authority, and then I accept it does come to this, if you weigh that in one side of the scales against Mr. Perrin's short evidence on the other, to the effect of, I don't believe on the basis of this process that he identifies, that notwithstanding all of those contraindications from the agreement itself, that CC Europe in fact had our authority to bind us, then that we do say is where the judge went wrong, and then went wrong further in finding that clause 12 did not bind CCLLP in any event.
So are you saying the judge should have disbelieved Mr. Perrin's evidence because it's implausible that there wouldn't have been compliance with the internal mechanism? So you're saying he should have rejected Mr. Perrin's evidence as inaccurate? Or are you saying that even accepting Mr. Perrin's evidence that there was actually no authority given because the internal processes were not followed as they should have been, that he should have then said, but there was apparent authority, or you have the better of the argument on apparent authority? What are you actually saying?
What we're saying is, if you pay due regard to the wording of the contract itself and its background circumstances, Mr. Perrin's evidence limited as it is to the identification of an internal process and a belief that given that process and his recollection that authority was not given, that evidence, not, I have searched Clifford Chance's files in relation to this matter or the Golders dispute, and on the basis of that, I can say conclusively that no authority was given. That evidence, limited as it was not sufficient to displace the natural conclusions that follow from the wording of the agreement itself, such that on actual authority, Soc Gen still had the better of the argument. And
So it is an appeal against the judge's factual finding as to whether there was actual authority.
well, to an extent, but only to this extent. It's an appeal against the judge's conclusion, based on the agreement itself and that finding on authority, that Soc Gen did not have the better of the argument on actual authority. And then to answer my Lord's question fully, if we're wrong about that, we say that the same analysis applies to his finding on Soc Gen not having the better of the argument on apparent mandate too.
Because you see, I mean, it's a very different approach this court takes to appeals on interpretation of an agreement, which has one accurate meaning or not, and appeals against judges' evaluation of evidence.
I accept that, but here, of course, to the extent that there is that challenge to the evaluation of the evidence, that challenge is brought almost entirely on the basis of the wording of the contract, because that was the evidence before the judge, other than the evidence as to CCLLP in fact complying with the terms of the framework agreement.
So all the points you're making today were addressed by the judge, weren't they, dealing with the actual and apparent authority at paragraphs 103 to 106 of the judgment. He deals with the words in the agreement, he deals with the fact that Clifford Chance abided by the fee maximum exception, and he weighed all that against the evidence of Mr. Perrin in the context in which it was provided, and reaches his conclusion. Now, going back to the grounds, I accept it's not conclusive, but one would expect the grounds to then be fleshed out in the skeleton. I don't think I find anywhere in the skeleton any reference to, other than one passing reference, to these paragraphs of the judgment or any challenge to them. Am I wrong about
Well, we deal with it, and I accept we deal with it, not in the type of details which my Lord refers, at paragraph 34 of the skeleton, tab 9 of the core bundle, page 109.
Forgive me, where are we at? I'm sorry. where are we?
Paragraph 34 of our skeleton. But my Lord, in taking this, I don't suggest that there we articulate the challenge in the way that my Lord has just identified how the challenge could have been made.
Can you be, at some point, you'll be specific, I hope. You say at the end of 34, a paragraph which I've got quite a lot of annotation about, but you say all Clifford Chance entities it dealt with did act as though bound by the framework agreements. Are you saying they acted consistently with the framework agreements, or you actually say they dealt with it, did act as though bound by? You understand the difference I'm trying to draw out? If you act as if you're bound, you act as if you are parties to it. So you generally look to see whether your conduct is explicable in any other way. It's under English law. If you're saying, have you become a party to a contract by conduct? The question you normally ask, I think, is whether there is any other explanation for your conduct other than that you are actually bound, such that if you just act consistently with, that is, I think, often said not to be good enough. In this case, for example, it might be said, well, Clifford Chance LLP may have acted and billed consistently with the agreement, so as not to put Clifford Chance Europe into breach, but it's not acting as if it were bound by the agreement, I actually a party to it. What was the evidence as to what Clifford Chance LLP had done, which is only explicable on the basis that it was a party to the framework agreement?
Well, the evidence as reflected in the judge's findings was
But
that
I want you to tell me what it is actually. Can you, at some point now or later, can you actually be specific about the findings and the evidence?
it was the billing by reference to the agreed rates, and as those agreed rates changed over time, the application of the rebate to the billed fees, and also the compliance with the reporting obligation, so that these matters, the Goldas matters, were recorded in the yearly reports that had to be submitted to SocGen, identifying the matters required in the later framework agreements by Appendix 3. Now, I accept that that may be no more than conduct consistent with the framework agreement applying rather than CCLLP being bound, but as I've indicated, it was something that needed to be taken into account and due weight and regard paid to it when deciding whether SocGen had the better of the argument that CCLLP was in fact bound. Because that conduct obviously goes to the question of both actual and actual authority and the French concept of apparent mandate. Because I don't want to suggest we break if I haven't answered the question that Lord Justice Snowden has just put to me, but I see the time, not that time, but the actual time, and wondered if...
Yes. Should we rise for 5 minutes?
Still on.
My lords, can I try and draw some of the various different threads that I've been developing in answer to my lords?
Yes, we've been interrupting you a lot, so do now get back on track as best you can.
As best I can, my lord, exactly. And can I, without in any way, I hate unduly repeating that which has come from my lips already, say why we say the judge was wrong on his finding that we did not have the better of the argument that CCLLP was bound as a party, and then even if they were bound, not bound by clause 12. My lords has the point, I think, that we say that the judge failed to give due weight and regard to the wording of the framework agreement itself. And secondly, picking up on the point made in the order granting us permission to appeal, equally to the inherent probabilities, the effect of the judge's finding is that CC Europe purported to make the framework agreement as it did without authority from CCLLP, notwithstanding its terms. And we simply say it's much more likely that the agreement means what it says and that CC Europe had the authority it said it did.
I understand that in paragraph 105, the judge expressed he referred to the inherent probabilities. He plainly had those in mind.
Well, he did, but that's why our submission is that he failed to have sufficient regard to those inherent probabilities, because if one takes account of the wording of the agreement itself and the inherent probabilities, and next, the point I was going to make, which I've referred to already, the evidence of CCLLP abiding by the detailed terms of the framework agreement. And we do rely on the judge's own finding as to the intentions of the parties and as to this being a framework agreement to apply throughout the world. Then not only the starting point from the agreement, but the natural conclusion to draw from the wording of the agreement and all of those other facts and matters was that CCLLP was bound. Now, as against that, you had the judge's evaluation of Mr. Perrin's evidence, and we've spoken quite a lot about Mr. Perrin's evidence, but it might just be worth turning it up. It's in the supplemental bundle at tab 17, page 244. And Mr. Perrin starts in paragraph 1 by saying he's a partner in CCLLP, and he's making this evidence in response to Mr. Fowler's evidence. Interestingly, at paragraph 4, he says that between 2003 and 2021, he was executive partner and general counsel at CCLLP. Now, one of the problems in this case, and it's a fault of perhaps both parties, it is, although we say ultimately it's the fault of the way that CC has structured itself and its affairs, it is the sometimes lack of precision in which entity we're talking about. Because of course we know that Mr. Perrin cannot have been General Counsel of CCLLP since 2003, because one of the points Clifford Chance prayed in aid in answer to the earlier framework agreements was that CCLLP itself had not begun to exist until 2006. But of course, to an extent, what Mr. Perrin says here about his role throughout the world is entirely consistent with Soc Gen's case as to how Clifford Chance conducting itself in terms of holding itself out as a single firm, but also for matters such as these framework agreements to have, so to speak, global reach. But when it comes then to the framework agreements themselves, Mr. Perrin's evidence at the end of paragraph 5 was that, for the reasons he comes on to explain, he did not accept that CCLLP was bound. In paragraph 6, he then gives perhaps some confusing evidence about how CC entities can become bound, because my lords will see there, his evidence was that there was a firm policy that any Clifford Chance partner wishing to enter into an agreement with a client binding any Clifford Chance entity beyond the office or offices in that partner's own country is required to refer that client agreement to the centre. Now, pausing there, there's obviously a difficulty about the use of entity and office, because we know that CCLLP is effectively the Clifford Chance mothership, in that it has offices in London, in New York, Frankfurt, in Dubai, as we've seen. So the idea that, for example, one of the partners in Dubai wishing to enter into a retainer with a client on behalf of the Clifford Chance entity in Dubai, CCLLP, would need to get Mr. Perrin's sign-off is slightly difficult to understand, but there is this quirk, if you like, in Mr. Perrin's evidence in not drawing the appropriate distinction or explaining exactly what he means by Clifford Chance entity and Clifford Chance office, or office in the partner's own country. But that's what he says about the policy, and then that's the launch pad for paragraph 7, which is simply that he does not recall approving any of the framework agreements. They do not bear any sign that they've been vetted and approved by himself or his colleague Angela Robertson, and he suggests that they would not have approved a draft if it was not in English. And on the basis of that, he ventures his belief that no approval was either sought or given to CC Paris or CC Europe in respect of the framework agreements, and then he makes an inference. So this short evidence, which we did criticise as being unduly short before the judge, which criticism the judge dealt with, we say, unfairly, by saying, oh, well, he only had to deal with things shortly because SocGen had not put in evidence that there was actual authority. That's a timing issue. But this short evidence was, as we submitted below, entirely unsatisfactory. It identifies in the most outline terms, without any reference to documents, a firm-wide policy that is said to have existed. It does so in terms which in and of themselves confuse entity and offices. And even then, that is provided as the basis for no more than a belief based on no documentary evidence other than the framework agreements themselves and no apparent searches of Clifford Chance's own records, that authority to enter into the framework agreements was neither sought nor obtained. And my lords, we do say, when weighed against everything else that we sought to place in the other side of the scales, and most particularly the wording of the agreements themselves, with respect to Mr. Perrin, that doesn't do the trick. If Clifford Chance are going to say against all of that evidence and the wording of the documents themselves, we were not bound, CCLLP were not bound, because we did not give our authority to our Paris office to enter into a contract expressly on our behalf and expressly saying it had our authority to do so, then this doesn't pass muster. And where the judge went wrong, in light of the agreement he had in front of him, together with, we say, with everything else that I've identified, it is to conclude that this was sufficient to effectively overturn everything that would normally follow from the agreements themselves, so as to enable him to conclude that SocGen did not have the better of the argument, that CCLLP was bound by the framework agreement.
So do you say that this, in the usual approach if the court is to say that it would only interfere with a finding of fact, such as the one the judge made in paragraph 105 of his judgment, if it was unsupported by any evidence, or if it was one that no reasonable judge could have reached. What do you say? Is that the test you say we should be applying?
My Lord, we accept that is the test that you have to apply, and it's the test I think my learned friend is going to press upon you. But of course, the test falls to be applied, or at least there's a gloss applied to the test in circumstances where the findings below have been made only on the basis of documents, and instead of by way of contrast to a trial.
Yes.
But we do say with respect to the judge below that, as I've sought to impress, he failed to give sufficient weight to that which he should have done, in particular the wording of the agreement himself, and gave too much weight to the unsatisfactory evidence of Mr. Perrin, with the result that his finding was one that satisfies that test, was a finding that took into account irrelevant matters, gave too much weight to some and not enough weight to others, and therefore a finding with which this court can safely interfere. And that's all. I'm sorry, my Lord.
I think there's also authority, isn't there? May have been cited, I may have missed it. That this court must give particular weight or respect to the views of a commercial court judge as to what constitutes a good arguable case, particularly in the context of jurisdiction disputes.
I'm not sure that particular authority has been included in the bundles, but I think it may have been referred to in I think Zephyrus, but we can check. But my lords, I certainly wouldn't seek to persuade you that that isn't the approach. But one has to look at the position here and look at what was before the court in terms of the contract itself and all of the other factors I've identified on one side, on the other, the evidence that I've just taken you to.
That's obviously the nature of a balancing, a weighing exercise, isn't it? And you have to persuade us that the judge got it very wrong.
My lord, I do have to do that, and we say with respect that he did, for the reasons I've been articulating.
Yeah. But is there much more you can say about it than that? So on the one hand, you've got the terms of the contract and the inherent probabilities. And on the other hand, you've got Mr. Perrin's evidence. I mean, you're not addressing us. I think my lord invited you to do this earlier, or to say, well, what do you suggest could have happened here? But are you suggesting that authority was given by someone at CCLP without Mr. Perrin knowing? Or are you saying that Mr. Perrin is simply his version is not right or not credible as to the process? And this was he's right to say this was a French language agreement. Are you saying he's wrong to say that CCLP wouldn't have approved, given authority without seeing it in English?
I think, my lord, the way we put it is like this. Before one gets to Mr. Perrin's evidence, the natural conclusion that
We've got that.
Yeah.
Yes, firm. I really assure you, we got that.
And if Clifford Chance were then going to call into question that conclusion by calling into question the issue of authority, then Mr. Perrin's evidence does not go anywhere near far enough in establishing an evidential basis for the absence of authority, so as to dislodge the natural conclusion.
I understand that's your overall conclusion, but I think what I was asking is, are you able or willing or prepared to be more granular as to what you say? How does one analyse this? When we have Mr. Perrin who says that he was in a position to know, and are you saying that he must be wrong, or that somebody else CCLP not identified who had the authority of CCLP LLP must have given the authority, and it's difficult to see how one gets round Mr. Perrin's evidence.
Well, one does it in the more granular form, as I've sought to indicate, namely that the highest that Mr. Perrin puts it is that there was a policy of some sort, which in itself, in its description, has some flaws in it, as I've identified. And then on the basis of that, and without doing any documentary checks by reference to the files or anything else of that matter, he ventures a belief, no more than a belief, that as a result, there was no authority here. And what we say is, well, that may very well be Mr. Perrin's belief. We don't suggest he's not telling the truth, nor did we before the judge. But one has to look at what the agreement actually says and the inherent probabilities. Is it really probable, more probable, that Clifford Chance Europe was effectively acting on a frolic of its own, signing up CCLLP in the express terms that it did? Or is it perhaps that the policy wasn't quite in place and observed in 2012, as Mr. Perrin says he thought it should be, or that someone at CCLLP, whether Mr. Perrin or someone else, did give their authority to CC Europe to contract on this basis? And we say that's far more probable. And when one's looking at the better of the argument case and doing the weighing exercise, that's inevitably the conclusion that falls.
Well, the judge's ultimate conclusion, the last sentence of paragraph 105, I consider that Mr. Perrin's evidence allows a reliable assessment to be made that no such authority was in fact given. And you have to say that that sentence is plainly wrong.
My Lord, yes, and we say it is for the reasons I've articulated.
Yes.
Now, my Lord, that leaves apparent mandate, and here the judge appears to have adopted a slightly different position, because as my Lord Justice Phillips identifies, it seems that at paragraph 105 the judge actually felt prepared to say that he could form a reliable assessment on the basis of the evidence that there was no actual authority, whereas when it comes to apparent mandate, the judge appears to have been in limb 3 of the test for good arguable case, as he identified at paragraph 79 of the judgment, namely that, and this is from the end of paragraph 106, his finding was that Societe General had not shown a plausible evidential basis that would support an argument on apparent mandate. So here what the judge appears to be saying is, well, there is a disputed evidential picture. I can't form a reliable assessment that there was no apparent mandate. But once I then get to stage 3 of the good arguable case test, as he's articulated it, and with which we take no issue at paragraph 79 of his judgment, I just don't think that Societe General has shown even a plausible evidential basis. And again, we say that that's wrong for very many of the same reasons that I've been setting out in relation to actual authority. It ignores or fails to give due weight to the clear wording of the framework agreement itself.
Forgive me, I understand that you can say the clear wording of the framework agreement is relevant, admissible as to whether there was actual authority. But I don't understand how the clear wording of the framework agreement can be relevant to whether there was a holding out by CCLP.
Well, under French law, an apparent mandate, as the judge identified in the judgment, apparent mandate looks at whether the contracting party here, Societe General, had a reasonable belief that CCLLP, or rather CC Europe, had the authority of CCLLP, and the wording of the agreement.
Just the judge sent this out at paragraph 66.
He did.
Article 1156 of the Civil Code. the contract will be enforceable against the principal where the contracting third party has legitimately believed in the reality of the agent's powers, in particular due to the principal's behaviour or statements, which doesn't sound a million miles from English law, in fact, that you have to believe that the agent has authority in reliance on the principal's behaviour or statements, not the agent's principles or statements. So the fact that the agent signs a contract that says I am acting on behalf of CCLP isn't a statement by the principal. It's not a behaviour or statement by the principal. So what at the time of entry into the agreements, the ones that are relevant, do you say what was the evidence as to the legitimate belief of SocGen, and what was it based on?
Well, in terms of the latter, one has the evidence of compliance with the earlier framework agreements, and I've made my submission on that.
Well, actually, you haven't, because you haven't taken us to what the evidence is, but because the judge expressly says that acting consistently isn't good enough. But if we're looking at apparent mandate, it's apparent authority to enter into the agreement at the time of entry into the agreement. We're not talking about subsequent ratification or anything else. So I'm just trying to pin you down on apparent mandate, which, as I understand it, is the same as apparent authority. What at the time of entry into of the 2012 agreement did SocGen put forward as the basis for their legitimate belief that the French gentleman whose name I'm sorry I've forgotten again,
Mr. Worley.
Mr. Worley had the authority of LLP? What was the evidence from SocGen that you criticised the judge for not having?
Well, the evidence was the evidence that the judge does refer to in the form of Mr. Fowles' witness evidence, which he refers to at paragraph 106.
But that doesn't. None of that relates to CCLP's behavioural statements, does it? In fact, quite the reverse. It limits it to CC Europe's negotiations.
My lord, yes, but one goes back to the rather particular circumstances of this case, where we are dealing with CC Europe as the Clifford Chance entity in Paris, saying what it is about its actual authority to act on behalf of CC LLP. Now, I can't, of course, say that that's a representation by CC LLP, but one goes back to the inherent probabilities and the reasonableness of the belief, which, on the evidence as to French law, the very existence of the belief in the apparent authority of the agent was, on Clifford Chance's evidence, to be judged objectively. So not by reference to the subjective belief of anyone within SocGen, but in the circumstances, objectively, what would a commercial bank in the position of SocGen believe the position to be? And we would say the answer is obvious. But can I identify a representation made by CCLLP alone crossing the line to SocGen on the evidence? No, I can't. I accept that.
Well, what the judge says at the end of 106 is that SocGen had not adduced anyone responsible for negotiation. First of all, as to what, if anything, they were told by CCLP, but then, or that they believed CC Europe to be contracting on CCLP's behalf.
Well, that last point is in particular engaged by the last submission I made, in that, well, what else objectively would a person contracting with CC Europe on the terms of this framework agreement have believed? They could have believed nothing other than that CC Europe was contracting on CCLLP's behalf.
But that isn't. It may be legitimate belief, which is fine. Of course, they may believe
Yes.
it, but it's not enough to bind the principal unless unless it's based upon something that the principal has done, i.e. the principal's behaviour or statements. That's the missing piece. I mean, if there was evidence from Soc Gen saying, well, of course we believe that Mr. Worley had authority to act on behalf of CCLP because CCLP had previously said or behaved in a certain way, then you would be hitting 1156 of the revised civil code, because you would be providing evidence that their legitimate belief was due to the principal's behaviour or statements. But there's no evidence. So how can you criticise the judge for saying there just isn't any evidence of what French law requires?
Well, the two answers I give to that is, first, the evidence that there was, as found by the judge, that CCLLP had been complying with the previous, or had behaved consistently with the terms of the earlier framework agreements. So they were charging the agreed rates, they were doing the discounts, they were providing the reporting.
That's the evidence at the moment I haven't got my handle on, so you better take us to what that was.
My Lord, yes.
But that would have to be based upon prior conduct to the 2012 agreement.
It would, and there was evidence, and there were relevant findings on that. The actual evidence we haven't burned this court with consists of whole rafts of fee notes and the reporting, but it is reflected in the judge's findings, which, let me just turn up. So first of all, at the core bundle, tab 5, page 55, at paragraph 41, this is in the context of the judge's consideration of the 2009 framework agreement. And at paragraph 41, the judge finds correctly, on the basis of the evidence before him, invoices for work on the Goldust dispute, for example, one dated the 5th of August, that should be 2009, not 2019, indicate that CCLLP applied the agreed hourly rates, i.e. the updated rates set out in the Appendix 5 to the 2009 framework agreement, and the agreed 7% discount. And then 42, reports dating from at least 2010 indicate that CCLLP was providing to Soc Gen periodic reports that were compliant with the reporting requirements set out in the 2009 framework agreement, which included details of the work done on the Goldust dispute. So it's not just applying the agreed rates as they've changed over time through the changed framework agreements generally, it's particularly in relation to the Goldust dispute, and then beyond the rates, the discount, and then beyond the rates and the discount, the reporting obligation was complied with, and again, specifically in relation to the Goldust dispute. And then I think if my lords go on to page 57 and paragraph 61, I'm sorry, page 57, paragraph 57, page 61. And this is really just for completeness insofar as the judge's findings are concerned, because we are now in the context of the later framework agreement, so I accept after the event, that the judge also found there that CCLLP continued to apply the updated agreed hourly rates in its invoices for work on the Goldust dispute, and gives an example.
I mean, you say you haven't burdened us with these documents. I mean, what are they? I mean, do they actually refer to the framework agreements,
No.
or are they just, they happen to be consistent with them?
They don't refer to the framework agreements.
So it's nothing like CCLP saying, hereby in accordance with the agreement to which we are bound is this report.
No, the highest that evidence came was an email exchange at the outset of London taking on the Goldust retainer, in which there was reference made to applying the agreed hourly rate. But there was not an express reference to those being agreed in a framework agreement. It was that the retainer going forward would be subject to the agreed hourly rates that were then in force.
Yeah, because where this all leads is to the judge's finding in the second sentence of paragraph 106 that we've been looking at, that the fact that CCLP subsequently abided by the agreed rates and reporting mechanisms is not sufficient, since it's equally consistent with CCLP simply having lived up to undertakings given to SocGen by CC Europe alone from 2008 onwards. So you have to say what? Do you say that's wrong, or do you say the judge applied the wrong test, or what?
We say again it's wrong because it fails to pay due regard to everything else I've been making reference to, but effectively standing back and just asking about inherent probabilities. What's more probable here?
But is this based on apparent? This is under the heading of apparent mandate, so it's not under the heading of subsequent adoption by conduct, or is it? What's the legal framework that you're asking us to apply here to say that the judge was wrong?
No, here we are dealing with only apparent mandate.
What's done subsequently can't affect apparent mandate, can it?
No, it can bear on the weighing of the probabilities for actual authority as to whether it's likely or not that CCLLP did have CC Europe had actual authority to bind CCLLP. But I think it must be right that it wouldn't be relevant to apparent mandate. That's where the judge's findings as to prior conduct would be relevant.
So you say the fact that CCLP rendered invoices and reports which were consistent with but didn't refer to the earlier agreements signifies, or was what, a legitimate basis for SocGen to assume that Mr. Worley was given authority to enter into the later ones?
My lord, yes, and therefore as a result, that if, as the judge seems to have found, this was a case where he couldn't form a reliable view on the evidence, but was in limb 3 of the good arguable case test, then he was wrong to find that SocGen had not shown even a plausible evidential basis that would support an argument of apparent mandate. There was a plausible basis shown, and to the extent that the position was uncertain on the face of the evidence before the judge, that was a product of one, Clifford Chance not producing what one might expect them to produce if they really were going to put authority in issue, and to the chronological point that I made towards the outset of my submissions as to how the point developed. It wasn't fair to criticise SocGen for failing to adduce further evidence on a point where, given everything else, the conclusion in our submission that failed to be drawn was obvious.
Slightly struggling with why the fact that CCLLP had previously abided by the framework rates and reporting and rebates, and it wasn't a party to the framework agreement, whether expressly by authority or apparent authority, means that it held out, what gave reason to believe that Europe had authority to bind it in relation to the 2012 agreement.
I think two answers to that, my lord. The first is, of course, we say that CCLLP was bound by the earlier framework agreements, but leave that on one side and assume that...
If that's the case, all this argument is unnecessary, isn't it?
My lord, perhaps, although, of course, I have to not too readily accept that position, because our position is that, our primary position at least, is that the dispute is covered by the 2012 framework agreement.
Yes, but what you're addressing us on at the moment is the argument that whatever had gone before CCLLP was bound into the 2012 agreement de novo.
forgive me, my lord, yes. Assuming against us that CCLLP had not hitherto been bound, then we can nevertheless point to that conduct in support of the position or the proposition that then when the 2012 framework agreement comes along in the terms that it does, it's reasonable for SocGen to believe that CC Europe is doing what it says it's doing. But I can't, I think, put it any higher than that. Now, my lords, insofar as the jurisdiction clause itself is concerned, we make one or two further submissions. The first is that the wording of the clause itself, which we see in the supplemental bundle at tab 8, page 153, is unambiguous and must be applied purely and simply without distortion as a matter of French law, such that if CCLLP is bound by this clause, then the present dispute is a dispute falling within the third sentence of clause 12 and must as a result be brought before the High Court of Paris. Now, the judge found that the framework agreement did not unambiguously state that the choice of law and jurisdiction agreement would apply to individual retainers. And we would say that that was an error for at least two reasons. The first is that that puts the question the wrong way around. The framework agreement did unambiguously state that disputes would be the subject to the exclusive jurisdiction of the French court. And one is at this stage working on the hypothesis that, of course, CCLLP is bound by this agreement. And secondly, the individual retainer here was silent, that there was nothing there or otherwise to displace the application of the jurisdiction clause in the framework agreement. Next, my lords, we say that that's an entirely unsurprising conclusion, entirely unsurprising for a large multinational bank to put in place a global framework agreement with its chosen legal advisors, itself a multinational law firm practicing from very many jurisdictions throughout the world, and for the terms of that agreement to govern the provision of legal services by whichever office or entity of the law firm to whichever office, entity or subsidiary of SocGen as the client. It is, we would suggest, equally unsurprising that SocGen as the client would wish for that agreement to be governed by its home law and to be subject to the jurisdiction of its home courts, namely the courts of France. And we say that's all the more natural a conclusion to draw in circumstances where the parties contemplated, and as turned out with the gold dust dispute itself, that Clifford Chance would be providing advice even in relation to particular matters across different offices in different jurisdictions. And so we say that the judge erred in construing this clause as a matter of French law because the clear words applying those words provide for this jurisdiction dispute, jurisdiction clause to apply to the present dispute. The only other point taken, I think, by the judge against the construction of the clause contended for by SocGen was the what might be called the Batonnier point, relying on the second sentence. Lord Justice Males, in giving permission to appeal, described this as a neutral point and effectively suggested there was at least a real prospect of success on our construction, namely that this simply provides that disputes falling within the jurisdiction of the Batonnier in Paris will be referred to the Batonnier in Paris, but everything else is caught by the overarching jurisdiction clause in the third and final sentence, namely any other dispute, and those disputes have to be brought before the High Court of Paris. So, my lord, for all of those reasons, we say, with respect, that the judge went seriously wrong and should have found that SocGen had at least a good arguable case, the better of the argument, that CCLLP was bound by the framework agreement and was bound by the governing law and exclusive jurisdiction clause. My Lord, that then brings me briefly, I think, to ground 2 of the grounds of appeal, and why we say the judge erred in not staying the claim brought by CC Europe in any event. And my Lords, I think I can take this pretty shortly.
Can I just before you do,
My Lord, yes.
where does the judge deal with the point that Lord Justice Zacaroli raised earlier, that this clause on your interpretation says that it's any other dispute howsoever arising in the past between the parties shall be brought before the High Court of Paris, as opposed to just saying any other dispute arising under this agreement shall be brought before the High Court of Paris?
I'm not sure that the learned judge did expressly address that. He deals with the construction of the...
Because you have to say, don't you, that this clause means any other dispute not just under this contract or relating to work services rendered under this contract, because you claim that the negligence took place under previous relationships. Well,
primarily earlier.
Yes, you say it's a continuing.
Yes, and we do say it's a continuing contract, and these are the contractual terms that govern the position from the moment that they're agreed, and that they apply to disputes, not only disputes arising after their agreement, but disputes in relation to alleged acts of negligence or breach of contract whenever those disputes arose. In the same way as if, as I gave the example earlier, if these terms introduced a limitation of liability clause, Clifford Chance would rely on them, notwithstanding that the relevant acts of negligence occurred earlier.
I don't, because I couldn't really pick up where this timing point is really dealt with anywhere.
I'm not sure it was, my Lord. I mean, in terms of the 2012 framework agreement, it's paragraph 107 of the judgment, where the judge does cross-refer to his earlier analysis at paragraphs 92 and 93, but those paragraphs, I think, were directed more towards whether the jurisdiction clause would apply to individual retainers rather than to the timing point. So I'm not sure, I'll be corrected, I'm not sure if the judge did expressly direct himself to the point raised by my Lord Justice Zacaroli.
Can I also ask you, you're therefore not going to address us on your arguments as to why CC LLP was bound by the terms of the 2006 framework agreement?
Not beyond what we've said in writing. My Lords will understand that that gets us so far in terms of the relevant background, which we say falls to be considered when looking at the later agreements, but the 2006 framework agreement does not include a jurisdiction clause. So to speak, if I only won on that, it would be the most Pyrrhic of victories. Now, my Lord, just turning then to ground 2, which of course only arises if we are unsuccessful on ground 1. And so we proceed on the basis that the judge's findings that CCLLP was not bound by the framework agreement or the exclusive jurisdiction clause within them are undisturbed. The judge found, paragraph 109 of his judgment, that CC Europe is bound by the jurisdiction clause. He obviously also found that CCLLP is not bound and so is free to sue in England. And he then held at paragraph 111 of his judgment that no substantive claim was being brought against CC Europe by Soc Gen. And that factor, together with the fragmentation of proceedings, which would result from preventing CC Europe from suing in England for its negative declarations, together with CCLLP, together constituted an exceptional or strong reason to refuse a stay. Now, my Lords, there is again no dispute about the relevant law. If, as is the case, CC Europe is bound by the jurisdiction clause, it is accepted that strong reasons have to be shown to refuse to stay a claim brought here in breach of that exclusive jurisdiction clause. And we say, in short, that the reasons identified by the judge do not come close to constituting strong reasons so as to justify refusing to hold Clifford Chance to the contractual bargain that it made. First, we say that whether or not there is a substantive claim against CC Europe is a matter of French law to be determined by the French court, applying that law by reference to the framework agreement. And the judge was wrong to conclude that no substantive claim was being brought against CC Europe.
What is the claim against CC Europe?
Well, second, that's my second point, is that Soc Gen does bring a substantive claim against CC Europe. It sues both CC Europe and CC LLP in the proceedings in France.
What for?
Well, and in its formal demand, its substantive claim against CC Europe is that CC Europe is liable under the framework agreements, under the French law doctrine of dominus litis. That effectively it had a supervisory role in relation to the Goldas retainer and is liable on the framework agreement for the negligent conduct of that agreement, if indeed there was negligent conduct of the agreement, as and retainer as Soc Gen asserts.
Looks like CC Europe is sort of vicariously liable for what CCLP did.
I'm not sure that the French lawyers would put it quite like that. I think it's more that there was a supervisory role and responsibility to ensure that the Goldas retainer was performed diligently. And
why would CC Europe have a supervisory role if CCLP was in fact a contracting party under the relevant agreement?
Because CC Europe is still, on this hypothesis, the contracting party and the only contracting party under the framework agreement. And as a matter of French law, it has that supervisory responsibility. Now, whether or not that strikes English eyes as a somewhat curious cause of action, Soc Gen is bringing that cause of action, and it brings it to as a matter of French law.
Sorry, I'm struggling with this. Your case is that they were both parties to the framework agreements.
Yes.
So on the basis of your case and your genuine belief of your client that they were both parties to the, directly parties to the framework agreement, why do you say that CC Europe has a supervisory role over CCLP?
Well, on this hypothesis, my lord, the judge's findings that the only party to...
Yeah, but I'm not interested in the judge's findings at the moment. Your primary case is that your client legitimately believed, for good reason, that they were both parties to the agreement. Now, take that as your client's legitimate belief, which is an assertion of fact that they had that legitimate belief. Why would they expect Europe to be supervising LLP UK in relation to litigation in the UK?
Because, as a matter of French law, CC Europe would also have that role alongside CCLLP.
Well, so is this right? Your clients legitimately believed, you say, that every single retainer conducted by any CC entity worldwide would be supervised by CC Europe?
Well, supervise is my English interpretation of the dominus litis doctrine. I can't do any more, not least because we haven't got the French proceedings before us.
Well, that's going to be one of my questions, actually.
Then identify on instructions, well, identify one, that which is not in dispute, that CC Europe and CC LLP are defendants to the French proceedings. Secondly, identify that which is not in dispute, that CC Europe, as well as CC LLP, was a recipient of the demand letter that articulated a cause of action against CC Europe. And thirdly, in order to try to assist on instructions, to identify the basis of the French law cause of action being asserted against CC Europe in Paris. And I can't go beyond or any further than that which I've identified.
What that would entail, it seems to me, would be that the French proceedings would involve a duplicative litigation of complaints against CCLLP in Paris.
It would. It would.
So you have exactly the type of ramification and risk of inconsistent judgments, etc., that in Donahue and other cases are good reasons for, strong reasons for not staying.
Well, dealing with the judge's reasons in order, was he right or wrong that there was no substantive claim against CT Europe with respect to he was wrong for the reasons we've given? Next point, was he right to find that the fragmentation caused by not ordering, by ordering a stay constituted good reasons or strong reasons to refuse a stay here? And there we say he erred because here that fragmentation on the judge's construction of the framework agreements was effectively created by Clifford Chance, the party that's trying to resist the stay. Because on the judge's construction of the agreements, CC Europe was only ever a party to the framework agreement. Separate to the framework agreement, there are all these other individual retainers to which the relevant CC entities, CCLLP, was a party, but not a party to the framework agreement. They would be subject to their own governing law and their own jurisdiction. And that is entirely of a piece with the type of contractual position identified, for example, in Concola at paragraph 42, where the court ordinarily won't find strong reasons to be made out, because the fragmentation and the risk of inconsistent decisions has been created by the contracting party who's seeking to avoid the stay. Put another way, on the judge's findings, CC Europe could hardly have contracted as it did. I mean, one really does sort of descend down the rabbit hole now. Contract as it did, saying it was contracting with the authority of CCLLP for and on its behalf, but apparently not having its authority to do so. Contracting on the basis that there would be a jurisdiction clause providing for disputes, at least with it on the judge's findings, having to be determined in Paris, and then turn around and say, but because our related entity, CCLLP, has successfully persuaded the court that it is not bound by that jurisdiction clause, it would be desperately inconvenient, procedurally inconvenient, if there were then fragmentation between the two different jurisdictions. And that's the very thing that they would have created themselves from contracting as they did. And they shouldn't be able to take advantage of that, but should rather be kept to their contractual bargain, which was that if and to the extent that there's a claim that either SocGen wants to bring against CC Europe, or here CC Europe wants to bring against SocGen, then SocGen and CC Europe need to litigate against each other in the courts of Paris. And my lords, there was one final point, which is that, as we've indicated in our skeleton, that fragmentation or risk of fragmentation exists, notwithstanding the judge's decision not to order a stay.
Because the French proceedings will continue.
My lord, yes. My lord, I'd indicated, if not promised, my learned friend that I would try to sit down by 2:45, and I failed in that endeavour. But I took that last ground relatively briefly, but it is set out, obviously, in our skeleton as well.
We've given you quite a lot of questions to answer, so you must make sure you've said everything you need to say.
But my lord, I'm sure there's nothing I could improve on orally that we've not already said in writing on that second ground.
Thank you very much.
Just on this second ground, this principle of dominus litis, do we have it explained anywhere?
I don't believe we do.
It just appears in the letter of demand at 197F of the supplemental bundle in translation.
That's right, tab 12, 197F.
That's it.
I believe that's right. I don't think it was covered in
I mean,
no, I don't think it was covered in.
my schoolboy Latin so probably doesn't go this far, but what does dominus litis actually mean? Is it just master of litigation?
Master of the litigation.
And
It's the person who benefits from litigation, isn't it?
I think is it.
well, it says you had been mandated to conduct as dominus litis
Yes.
adequate proceedings against 4 entities. So presumably, you say that would encompass both Europe and UK.
Well, Lord, yes, and that's why both are being pursued. And my master of the litigation comes from the way that the French has been explained to me, rather than my own schoolboy Latin.
Okay, so when it's said that in its capacity as dominus litis, Clifford Chance gave bad advice and submitted late claim forms and failed to effect service, I mean, that looks like it's only relating to the UK entity, doesn't it?
On its face, I can't go beyond what I've sought to do in terms of explaining what the French cause of action is and the fact that the two are being pursued.
Okay, all right, thanks.
Thank you. So it's 5-1. Do you want to make a start, or
I do want to make a start because there's a distinct topic I can deal with in those 5 minutes, and that's the question of what's been referred to as the timing point that you discussed, your lordships discussed with Mr. Chapman. That is the order and timing of the evidence as it came in below, and the answer to that is really quite simple. If we go please to the supplemental bundle and just look at the timing and content of the witness statements as they came in. The first witness statement was that of Mr. Fowell, and that was dated 27th of January 2023 and is at tab 13, page 198 of the supplementary bundle. And the essence of the challenge was in paragraph 22 at page 201, and it was limited, essentially limited to the statement, I understand from SG that each and every iteration of the framework agreements was negotiated between representatives of SG and Clifford Chance in Paris with the aim of regulating the relationship between all the entities in the SG group and Clifford Chance worldwide in relation to provision of legal services by the latter to the former. And as the judge correctly found, that was not enough to get Societe General home on their basic argument as to Clifford Chance LLP being bound by the jurisdiction agreement. Then what we see, and this is important, is Mr. Hewitson's witness statement, which is behind divider 14. And if we go please to page 225, paragraph 47.1, in which he summarises CC's position in response to the application. And you'll see 47.1, CCLP is not a party to any of the framework agreements and as such cannot be bound by the exclusive jurisdiction clause contained in the 2009, 2012 or 2015 agreements. It is free to litigate here in any event. So Mr. Hewitson, necessarily and obviously, because that was the primary basis of CCLP's objection to the application, that CCLP was not a party. Now it's at that point, but not before, that the question of authority and agency comes in, and that is only because if one goes to Mr. Fowell's second witness statement, behind divider 16 at page 238, he has something to say about French law. So if we go to page 239, it has a section that's headed Contractual Interpretation, Apparent Mandate under French Law. And I should have given your lordships the dates of those various witness statements, or Mr. Hewittson's was the 24th of February 2023. Mr. Fowell's second witness statement is dated the 12th of May 2023. And so he introduces aspects of French law, and then he deals with the French law of apparent mandate, apparent authority, at paragraphs 9.1 to 9.4 on page 240. So that is where, without evidential flesh being put on it, the issue of authority comes from. It is, of course, noticeable, and you've discussed this with Mr. Chapman, that there's no actual evidence from Soc Gen at any stage of these proceedings to back up the principle that they wish to rely on, or appear from this document to wish to rely on, with actual evidence. So it is at that point, and again, the date is important, it's the 7th of July 2023, the hearing was not until mid-September 2023, that Mr. Perrin's witness statement comes in. That's that's divider 17, paragraph page 244, and your lordships have been taken to that, and also a witness statement from a French partner in Reed Smith, again dated the 7th of July 2023, Mr. Daniel Kadar, which is behind divider 18 at page 248, in which he explains in considerably more detail the content and implications of the doctrine of apparent mandate. So that's where matters lie, some 2 months, over 2 months, before we have the hearing in front of Mr. Justice Henshaw. So I'm bound to say, we do not understand the timing point that's being made, some difficulty in responding, something which should influence the court's approach, it appears to be said, to the reliability of Mr. Perrin's evidence for lack of some opportunity, this is what must be said, on the part of Soc Gen to reply satisfactorily. So that's the factual position. And I'll move on to other matters, if I may, at 2 o'clock.
Yes, thank you. Very well, 2 o'clock.
What class?